Let's start off with intestate succession. That occurs when a person is like Prince. If they don't have any written documentation, no will, no trust, it means the state of California has a will for you. Because they realize that a lot of people don't have a will or a trust. So when that happens, the state law will dictate who receives your assets. California has a will for you, and basically it leaves it to your closest relatives, and there's a hierarchy. You don't get to choose. It will go to whoever the state says it goes to. Now, if you have a will, on the other hand, the will can express your wishes. The will designate who gets what, who will manage the distribution. And what do we call that person? An executor. If you have a trust, we call it a trustee. If you have a will, the manager is the executor. Who the guardians for your minor children will be, if you have minor children. All of that is set forth in a will. Your wishes with regard to your final disposition and the type of burial. Wills don't always say that, but sometimes they're very specific. Plant me under the oak tree in the backyard, and we can be very specific in wills. When you have a living trust, you also have a will. It's called a pour-over will. So the will is kind of a backup for the trust. We'll talk about that too. Some folks have the mistaken concept that a will is all they need, but I've got news for you. If you didn't know this, the laws have changed. Things are a little more complex today. The courts are more crowded. Probate is more expensive and time-consuming. And therefore, wills are a little bit antiquated. The laws now require that if you have a will, not a trust, that the estate goes through court, that the taxes have to be paid. You have the judge helping collect taxes to give to the government. When you have a blended family situation, if you have stepchildren, or something that's a little bit out of the norm, sometimes a will is not going to address those situations properly. Asset protection. The problem with a will is it's a public forum, and anyone can go down to the courthouse and sit in on a probate and even raise their hand and say, Your Honor, I believe I'm supposed to be entitled to part of this estate. And it slows the whole process down. And you have creditors showing up at court because, again, it's a public hearing, trying to get a piece of the estate. So even with the will, assets are still subject to creditors. People are living longer. The longer you live, the more changes that you may want to make to your estate plan. Is your family the same today that it was 20 years ago? No, your children have grown up. You might have grandchildren now. Maybe they've grown up. Maybe you want to change who's in charge. Maybe you want to change who gets what. So as people live longer, their wills become outdated. Lack of control. That's a problem with the will, because with the will, who's in control? It's the state, basically, through the court. That's right. And a will can also only control assets that are in your name, your individual name. There are certain other ways of holding title, like joint tenancy, for example, that a will can't affect. And this is a big problem because, for example, if you were married before and you had a life insurance policy and the policy names the previous spouse as a beneficiary, and you forgot about who the beneficiary was, and then you created a brand new will with your new lovely spouse, and you say, I love my spouse, I want to give them everything in my will. Who wins, the will or the old beneficiary designation? Well, the old beneficiary designation. The ex-spouse gets the insurance, and the will that you thought would control the insurance does nothing. So wills only control certain types of things. They only go into effect after you pass away. And a full probate is required in the state of California if the estate or the assets that are being passed are greater than $150,000. So sometimes people come to me and they say, Dan, I heard that I could leave $5 million or something like that to my loved ones without a problem. And now that may be true with respect to estate taxes, federal estate taxes that the government collects. But probate, the process of probating a will, that begins if your estate is over $150,000 in gross value, not net value. You could have a home worth $600,000. You could have a $500,000 mortgage. So how much equity? Just $100,000 of net equity. It'll still go through probate because it's the gross value that probate's calculated on. So basically, if you own a house and all you have is a will, there would be a full-blown statutory probate in a courtroom like this.